All right, so let's stay with that very story and speak to Mpumelelo Zikalala of Zikalala Attorneys. Kozeni, good afternoon to you. It's always a pleasure to have these conversations. The timing from the very beginning of this case was always going to be of issue, and this morning we saw that it came up again with, the questions around why today, why not bring it up at the end or even during this particular trial. But one of the things that is clear from listening to the former president's, lawyers is that they're kind of like trying to put some preventative measures to ensure that they don't want to find themselves arguing this at a later stage. Would you agree?
Definitely. Good evening to you, Mangat, and also to the SABC listeners. They're basically saying, let's engage in a preventative measure. Let's not deal with the matter after it has been moot. Let's not deal with the matter after we are appealing with this particular matter of charge to prosecute as well as other matters. Because at the end of the day, if they are successful on the charge to prosecute argument, then the matter would fall away in line with the order that they are seeking. So they are saying, if you don't allow us to take this matter to the Supreme Court of Appeals, in which we think may come to a different conclusion compared to you, certainly because one, the definition in which we are coming with and we want our courts to adopt, and in terms of we want our law to develop into, we are simply saying, let's not limit the title to prosecute to administrative issues only. Let's extend it to even the conduct of the prosecutor and say, if the conduct of the prosecutor is that of not of a reasonable prosecutor within the shoes of Advocate Piet Koen, then we stand to say that the rights of our client, in this case the former president, are going to be infringed. If that's the case, dismiss the matter and say there's a mistrial. If not, we may need to go to the Supreme Court of Appeals for it to decide on this particular matter. Let's also remember that you are dealing with two competing rights. Section 35 as per our Constitution, and also other legal prescripts as they apply in the NPA and the Criminal Procedure Act. So it's important to come to a reasonable conclusion or to come to finality when it comes to this matter, so that at the end of the day, this matter is put to rest. There's no other sort of a confusion as to what exactly does it mean to say that the person does not have title to prosecute.
And when one looks at, the issue of the title to prosecute, it's often looked at as an administrative, point. And as you say that they're seeking to expand this, looking at the conduct, looking at some of the accusations around the leaking of, medical records, as they suggest. I wonder if this was in any way, in your view, a good move to strengthen the case, because this is the same judge who last year threw this matter out and was quite emphatic that Advocate Piet Koen does not need to recuse himself.
I think what they've done, they've said, you have not dealt with what we have asked you to deal with in the first place. You simply rehashed the law as it's stated in the court cases decided by the SCA. So nonetheless, you are going to be bound by the decision due to the hierarchy of the courts that are applicable in South Africa. All that we need from you at this particular stage, grant us leave to appeal to go to the SCA. We want to advance the same arguments to them. Preferably, let's even advance the same arguments to the court, because we are dealing with the Bill of Rights matter. And if we are successful, then there are lots of other things which are going to come into our favor. I do not think, though, that even the court will come to the decision of saying, let's strike this matter off the roll. Let's make sure that it never sees the light of day due to the conduct of the prosecution. They may say, at most, remove Advocate Piet Koen as the lead prosecutor in this matter, get someone else to prosecute in this proceeding so that they may take over. Let's place another scenario. If the Advocate Piet Koen would sort of pass on today, God forbid, then the question would be, who would be able to step into his shoes? So it should not be the end of the state case, which is what the Zuma legal team is saying. But another person would come into his shoes. Now, if you really wanted this matter to be expedited as soon as possible, why not accede to that particular request, so that at the end of the day, you can see the first witness going into the witness box and seeing that at the end of the day, you have the settlement of this particular trial that has been going on for such a long time.
I wonder what all of this then means for the new evidence that was presented and suggesting that there's now a case against Mr. Piet Koen that is now currently unfolding. What happens then to that particular process as this particular one unfolds?
Let's remember to the nature of the application which was submitted by the former president. They're basically saying, firstly, I want leave to appeal. In addition, I want to supplement my evidence or the evidence which must be looked at by the court. In line with that, one of the information which is going to come in at that particular stage is the new evidence that you've been referring to. So the opening of a case at the SAPS, all the other allegations that have been there are going to make up these new allegations, are going to make up the new sets of records in which we then ask the SCA to look into this matter after it has considered all of those. Now, the one question or hurdle that they must face would be of the following. When did you know about it? Why did you wait for such a long time in order to present it? Is it a case of you wanted to present it at a later stage, even though it was available to you at an earlier stage? One of the questions or one of the hurdles that they might find is the following. The allegations of leaking of information is something that has always been there. Now, after you have known about it or you have become aware of it, former president, did you go to the NPA as the employer of Advocate Billy Down and say to them, your prosecutor is engaging in conduct which is unbecoming of a prosecutor. I want you to take steps. Did you go to the Legal Practice Council, for example, and say, a member of the Legal Practice Council has done 1, 2, 3, 4, 5. I want to be protected with some of these things. Then if you didn't, what was the cause of you not going there? And why do you want to go at this late stage when that particular opportunity has been opened to you? But the most importantly would be, would it have a bearing on the title to prosecute on the wider interpretation as they are seeking? My answer to that would be yes. However, will that result in the matter being stopped or with the prosecution against the former president being seized? I do not think so. I think the court will come back and say the merits of this matter must be answered to. If there are certain allegations in which you need to come to answer to in court, make sure that you come to court. The court will decide on your behalf on which evidence to accept and which evidence that we mustn't accept. But at the end of the day, it is in the interest of justice that these type of allegations are well ventilated in an open court and a decision is made at the end of the day.
And one of the things that, is clear even from last year as well, when these, this particular matter set in October and it essentially was not successful, is that the clearing differences and what the defense calls divisions of, especially when it comes to the opinion among the NPA itself, when it comes to this particular matter, are always going to be used, and you can almost get a sense of what's going to come when the trial eventually gets underway, if it actually doesn't. I mean, you look at the affidavit of Advocate Willie Hofmeyer, you're also looking at, Billy Downer as well. But I wonder, based on all of these facts and what we heard today, you think that Judge Piet Koen might be swayed differently here to say that, okay, maybe a different court may come to a different conclusion, even though I made this ruling in October, because we saw a similar instance in last year where the former president in the North Gauteng High Court managed to be able to be granted a different decision by the very same court.
If you look at the body language, maybe it might be a bit too far-fetched. But if we look at the body language of the judge when presentations were being made, the minute there was a word or mention of the word interest of justice, the protection of the accused's rights, you could see that he would start jotting certain things down and maybe as triggers which are going to remind him of those arguments when he's making his decision. So the most important stance that he may adopt, he may say, let's look at the prejudice which is going to be suffered by both parties here. With the NPA, there's probably going to be a delay of maybe, let's say, 6 months to a year, while this matter goes to the SCA or even the Concord if it needs be. Now, let's look at the prejudice that might be suffered by the accused. They are going to sit within a trial where there is an instance or a possibility that they might come out victorious on the no charge to prosecute argument. So in order for us to avoid all that time wasting, and I say that in inverted commas, let's make them go to the SCA so that they're able to argue this particular matter and we bring finality to this definition. Secondly, it is a common cause that at the end of the day, the Constitutional Court has never pronounced on this matter. The title to no prosecutor in a wider definition has never been tested within the Constitutional Court. The Constitutional Court may come to a different conclusion. They may say, let's look at other factors which may then come in. We want to take those into consideration, especially because we are dealing with the protection of constitutional rights, Section 35 of our Constitution. So anything which has to do or that may seem to be infringing our rights must be well ventilated, being discussed and being adjudicated by the courts. And you must reach finality as to exactly what does it mean when you say a person has no title to prosecute. So on those basis, he may weigh the two and say, let me grant them leave to appeal. They can go to the SCA and argue their matter, and maybe a different court will come to a different conclusion.
Koen, it's going to be quite an interesting road ahead, especially when you talk about the Constitutional Court as well, because tomorrow we are looking to, see those 4 candidates sit, and this might be just one of the first tests that the Chief Justice, who probably might be appointed at that time, might find themselves having to officiate over this particular matter. But let's leave it there for now and see how these particular, proceedings will fare, especially when it comes to the 16th of February, as to whether or not Judge Piet Koen could be persuaded to allow this matter to go to a higher court. Thank you so much for your time. That was Mpumelelo Zikalala of Zikalala Attorneys.